for all of it. The Ministry of Justice has trained more than 5,600 persons in restorative justice practices. More than 200,000 victims have been supported by the victim services. Legal aid has reached thousands island-wide. Make we talk it out, not fight it out. Call 888 Justice today.
But we will begin, and we'll ask Ministry of National Security to say prayers for us. Who are you going to? You will? Wonderful.
All right, let's bow our heads. Dear Lord, we thank you for today, your many mercies. You've given us one more day. Lord, as we contemplate the Child Diversion Act, dear Lord, you give us the wisdom and discernment. Allow us to have meaningful discussions that inure to the benefit of the children of Jamaica. We thank you for each and every one of us here, our parliamentarians, the technical staff, and we ask you to hasten the step of those that are on their way. We thank you. In your name we pray. Amen.
Amen. Thank you very much, Ms. Charles. Any apologies for absence? Ms. Tova Hamilton, but we have 4 members present in the chambers, and I think there are 2 persons, Senator Scott Motley and Shereen Golding, are online. He's online too? And
which one is he?
3 persons are online. Donovan Williams is also online. Before we get to the minutes, I think it's appropriate for this Child Diversion Committee to take note of the past 2 weeks, what has been happening in several schools. We see at Jamaica College and also in Seafort, in St. Thomas, incidents which really, even though JC was captured on video, to the best of my understanding and knowledge, is fairly widespread across many schools. And what took place at Seafort between 2 students should never have happened. And the extent to which the state, or by its various programs, can avoid these activities, we need to really see how best that we can assist and give support to the schools. There's no doubt that there are many programs to resolve conflicts and to deal with disciplinary matters. But here at the Child Diversion Committee, looking at the bill, we need not only to take note, but ask ourselves what more can be done to support the other agencies and even to undertake some of the challenges that students are faced with every day. The Child Diversion Committee has a limited mandate at the moment, where we deal with students or youngsters up to age 17 who get in conflict with the law. We have discussed here on many occasions the possibility of giving it some greater flexibility so that before the students actually commit an offense, we can anticipate that it will happen because of the rowdy, disorderly, sort of uncontrollable behavior, which the courts, when they see a child that has been referred to the court as uncontrollable behavior, they literally refer to child diversion, even though the mandate does include uncontrollable children. But I think, we have to work very closely with CPFSA and SISOCA. There cannot be firewalls between us. CPFSA and SISOCA, all the agencies will have to really work closely together because we have a real crisis in our schools. The students are taking behavior which they see every day in their communities and are taking it into the schools. And I have spoken to Minister Dana Dixon and also to the schools community how much more we can do from the Ministry of Justice and Constitutional Affairs to bring conflict resolution as a part of the program of the schools. Because what happened in Seaford, if the parties had been brought to restorative justice or mediation, then what took place with the killing of a youngster could have been avoided. And we get that on a regular basis, where children, right there in the communities, their families are with them, so the families may well be able to avoid any interaction or, anything arising. But when they get outside the homes or outside the neighborhood, be it at the bus stop, the transport center, or in the schools, they then take it out on one another. And we have to find a way to preserve not only the order, but the lives of many of our youngsters who, regrettably, many of them, unfortunately, lack parental control, and many of them are involved, unfortunately, in gangs. The sad thing is that you're having in many of the schools groups, I call them groups because I can't think they could be gangs, who are literally, fighting one another. And as a society, we need to take some measures. And this is where, colleagues, tomorrow we are going to be looking at each clause, the reassessment of each clause. But we have to, in our overall report and recommendations, see how best we can assist CISOCA, CPA, FSA, because right across every schools, we need to find a way to ensure that before they get to child diversion, that we reduce as much as the conflict which seem to arise in schools every day. So it would be remiss of me, colleagues, not to make these comments, because we are looking at child diversion, and then the last 2 weeks we have these issues just emerge, and these are matters which impact on child diversion, and we have to find a way to see how in our discussion and in our recommendation to Parliament we can give some support to the schools and generally to see in the communities how we can really prevent some of these disastrous and catastrophic events. So these are my opening remarks. I'm sure I speak for the committee in saying we need to look carefully at how we address these matters. And I'm sure members of the committee, when we get to go clause by clause, we're going to do a general assessment tomorrow. Okay? Bear that in mind. So I'm begging members of the committees that they can join us tomorrow. We do a general assessment and anticipate what could be clarified, amended, or improved in the legislation before we make a final report to Parliament. We may have one or two short presentation tomorrow, but I know this afternoon we are going to be fully booked out with the presentations from the Ministry of National Security and the JCF and CISOCA. So I'm not going to take up much more time, save and except now to ask the members. We have 2 minutes, the 3rd and 11th of March, which is a long time. If we could just approve them, there are at least 2 more minutes, which maybe by in another week or 2. But what is the projection, colleagues? We want to take all the presentation by next week. Those who are not available we can't take any more, because we want to make a report to Parliament in May, and the committee will be signed off sometime in May, so that a report can be presented to Parliament. The amendment to the Child Diversion Act can be dealt with soon after, and we moved on. But so far, we have had a significant, really beneficial committee meetings. But at the end of the day, we want to make sure that any improvements is to the benefit of our children across Jamaica. So without further ado, I'm speaking because you notice about half a dozen or so people came in a while ago. I was waiting on them because they're going to be making the presentation. So, so could we move any corrections to the minutes of the 3rd and 11th? So the minutes of the 3rd of March, moved by Member Buchanan and seconded by Member Dalrymple Filbert. The 11th, moved by Minister Dalrymple and seconded by Member Buchanan. Any matters arising that you'd like to raise? If not, we can go to the presentations. All right. So we have with us. We have with us members from the Ministry of National Security and the GSA.
Chairman.
Yes.
I apologize. I was trying to click my link to get on to you. I don't have any substantive corrections to the minutes. I accept that it has been moved. But in number 4, there's some typographical corrections in the name.
This is what date? What date?
This is the minutes from March 3rd.
The 3rd, yes. Page?
Yes. On page 3, Ms. Dehaney just needs a space there. On page 4, the title, a D, continued.
One second. Mr. Nash, just make a note of these corrections for me, please. Go ahead, continue.
As they are typographical, Minister, I'm happy to just send my markups to Mr. Nash.
Okay, thanks, Senator Sherin Golden.
The committee with that. Thank you.
Thank you very much, Senator Golden. Ms. Shauna Trowers, the Chief Technical Director from the Ministry of National Security, she's going to first introduce all the members coming from the Ministry of National Security and then indicate to us how you're going to proceed.
One more time, Chairman. Wait, one more.
One second. Go ahead. No, you're okay. Go ahead. No, leave it.
All right. So good afternoon, Chairman and members of the Joint Select Committee. As our chair said, my name is Shauna Trowers, Chief Technical Director with responsibility for Crime Prevention, Rehabilitation, Inspectorate Policy Division within the Ministry of National Security and Peace. I have 3 of my colleagues here, inclusive of a representative from the Department of Correctional Services. So I have to my direct left our Senior Assistant Attorney General, Ms. Rochelle Jagan. Beside her would be Assistant Crown Counsel, Ms. Natasha Wallace. And we have our DCS legal representative, Mrs. Stephanie Ebanks. All right. So I want to thank you for giving us this opportunity to present some of our
Before I go on, who is from JCF?
Do you want to introduce them as well now, sir?
No, you're in charge of them, so you go.
Okay. So how we would proceed is that the ministry would first make our presentation with the DCS, and then we would defer to JCF with the peculiar operational issues. So I'm going to ask Mrs. Ariel Brown-Blake to introduce herself and her team.
Good afternoon. Thank you again for the opportunity to be here, Minister. So I'm Ariel Brown-Blake, and I head the Legal Affairs Division. and I am the designated Commissioner of Police on this fine occasion. With me, right to my immediate left, is Mrs. Jamie Brown Bailey, also an attorney at law from the Legal Affairs Division. With us are Superintendents of Police, Kenil Henry from his Criminal Investigation Branch, although he is currently at Area 2 now, and Miss Kerry-Ann Bailey, who is the head of Sissoko. With her are Inspector Sharice Johnson, also at Sissoko, and a member of the Child Diversion Committee, and Detective Constable Blonette Barrett, who runs the Child Diversion Desk at Sissoko.
And then you have someone from Correctional Services.
And two other persons. I'm trying to say, okay, great. There is Superintendent of Police Courtney Coley, as well, from the Community Safety and Security Branch, and with him is Inspector Andrea Murray, also from the CSSB.
Okay.
I think that is the sum total of our representation.
So I'm going to ask you, Ms. Charles, to direct the proceeding as to who is coming on and so on, okay? So you go ahead.
Thank you, Chairman. It was remiss of me not to mention that we have our manager of youth at risk, Ms. Marjolaine Francis, with us as well. So, members, I will start off by giving the policy context in terms of what really underlies the considerations that the Ministry of National Security and Peace, as well inclusive of the Department of Correctional Services, has put forward. We have about 7 major policy areas that we looked at because we wanted to contextualize our recommendations. I would want to first say that the Ministry of National Security and Peace commends the proposals coming from the Ministry of Justice and Constitutional Affairs. Where we have not identified any particular peculiarity, it is that we are in agreement with the stated proposals. Also, having been very attentive to the JSC to date, there are some proposals that we did not repeat because we saw that it came from the Ministry of Education and other stakeholders like JFJ. And so we kind of streamlined our presentation to focus on the ones that we wanted to highlight. So that's what we would be doing today. So the first thing we looked at that we thought was an important policy context was the meaning and the intent of child diversion. And currently the Act defines the diversion as an alternative process for determining the responsibility and treatment of a child without resorting to formal adjudication by a court. What we want to recognize this principle as we go through the Act is that we want it to be more explicitly recognized within the concept of the Child Care and Protection Act. We feel that if it is only siloed like that with the necessary interaction, it leads to gaps, and we noted that through our presentation. And so we want to focus not merely on the offense. One of the critical things coming from national security and peace, we recognize that many offenders themselves are victims. And so therefore there has to be an intersection when we look at the child diversion, especially when we look at the objects of the Act. So that is our first principle that underpins the specific recommendations. The second one would be looking at the referral and decision making. And currently the Act allows for diversion at multiple stages, inter alia, the police interactions, court proceedings. In terms of the referral points and decision making, we recognize it is not clearly defined, and so we would want some guidance. As my colleague here, when we go through the sections, what we want to ensure that even though there is flexibility, it is not open to too much subjectivity. And there should be guidance in terms of what referral. We also gave regard to other presentations that looked at a tiered approach in terms of what referral looks like. And so that consideration we would want the committee to take on the advisement. The third one we look at is looking at acceptance and responsibility and consent. In this area, we're asking for greater clarity. and we believe it would be beneficial. Looking particular, and this will intersect with what you will see at our 7th point, looking at developmental and psychological assessments, which should really inform consent and acceptance of responsibility. The role of the police officers, and our colleagues from JSF will go in depth in that one. Right here, and I do know that the JSF will speak to the guidance based on their current procedure and what they will recommend in terms of providing for a general framework how discretion is supposed to be exercised. But this is a policy position that we concur with the JCF on, and we wanted to make sure that the JC recognizes that. The integration of case management in diversion. This is a particular recommendation coming from National Security and Peace, given that we've had quite a bit of success looking at a case management methodology. Now, what is important here is not that there aren't case files, but we're talking about a specific case management methodology, and for it to be mandatory. Chair, you referred to earlier the fact that we cannot work in silos, and in our discussions internally and with our agencies, that came up. How do we treat with the different agencies treating with the same child? And is our intent to frustrate the victim? And that would mean that we have to be very mindful of how information is shared. So we're looking at, and my colleague here will speak to our recommendations as we look at the case management methodology and how information is first garnered and how it is shared. We want to make sure it is more of probative and not prejudicial. So we've actually had a significant discussion when we're looking at the case management methodology here and what we're recommending for the committee. The diversion programs and interventions, we felt that there was scope for an expansion, particularly when we looked at substance abuse, education and treatment. And I targeted that because when we looked at the schedule, we recognized that substance abuse was not listed in the schedule. Having had quite a bit of discussions with the JSF, we're looking at things like marijuana use, the use of Molly, so forth. The landscape has changed. So the Ministry of National Security and Peace isn't proposing for hard crime drugs. So we're not looking at cocaine, crack. We're looking at those drugs that the JCF has had experience with youngsters. And they will further speak to this in terms of how do we include that into the schedule. And by virtue of that, through the flexibility provided, I think under Section 7, that we can provide for an expansion of the diversion programs, which the committee has the ability to do. So it may not necessarily mean amendment to the act per se, but we want to make sure that it is clearly defined in how we proceed with the policy imperatives. The last one on this page, which is something that we are very committed to, is the issuance of parental orders. Initially, we do know that this was a matter discussed when the initial child diversion came up, and it is something that we now see as critical. There has to be a recognition, I do believe, that in many of these cases, a part of the vulnerability stems from the home and assisting the parents. So we are not trying to propose any sort of I don't want to say adverse treatment of the parents, but it has to be that if a child is diverted, the ecosystem that child is in needs to also have this sort of attention. And so we have placed that there for consideration. And lastly, as I alluded to earlier, looking at children with disabilities in reviewing the Act, we recognize that there was a gap in this, and so we would want that additional provisions be considered to ensure that diversion programs are accessible. and we are recommending appropriate specialized assessment and interventions available to children with disabilities. I would ask my colleague now, Ms. Rochelle Jagon. She will take us through the specific amendments that are being proposed, and she will be also assisted by our colleague coming from the DCS, Mrs. Stephanie Ebanks, where appropriate.
I don't want to interrupt the flow, but usually my members have questions, so it's up to, should she proceed? Okay, wonderful. Press.
Good afternoon, Chairman, members. So, proceeding to advance or share the proposals coming from the ministry's team to include also the DCS, I will start by examining first the definition of the term consent on the Section 2 of the legislation. And it is the ministry's position that the term consent ought not to be determinative, and that the victim, or it really should not be based on the victim's consent or considering the victim's consent. It is believed that requiring the victim's consent it's almost considered as a condition precedent, and it may very well operate to frustrate the diversion mechanism and potentially fetter the rehabilitative objective of the legislation. So it is believed that including or expanding the word consent to include the victim's intervention is something that perhaps we can have some discussion around, because it creates almost a fetter on what we believe to be the intention and spirit of the legislation. Okay, and also now moving to the definition of child diversion and conflict with the law. From what the CTD had spoken to or had indicated just a while ago, there is also some merit in expanding the definition of child diversion to include the principles and reflect more definitively principles of restorative justice, rehabilitation, and reintegration. And I think this would capture the full extent and the full intention of a child diversion program in keeping with the best interests of the child. And then moving on to the Section 5 of the Act. As was previously mentioned, there should be some scope for consideration of a structured case management and oversight mechanism. So that is also another proposal that we believe would serve to provide a check and balance to ensure that each child's case is properly screened for diversion eligibility, and that no child who qualifies for diversion is inadvertently excluded from the program. With respect to the acceptance of responsibility in Section 9(2)(d) of the legislation, the recommendation advanced by the Ministry of National Security and Peace is that representation be afforded to the child offender at the time of giving consent. So there really ought to be an opportunity for there to be consultation with that child offender before the child's consent is given. And this is really considering the child's capacity to appreciate the seriousness of the offense and the serious nature of what it is that the consent that they're about to give would in essence, would cause. So for there to be some consultation prior to consent, we feel would allow for the child to be properly consider the gravity of the situation before them. With respect to Sections 13(1) and 2, the ineligibility for child diversion, we take note of the Ministry of Justice and Constitutional Affairs recommendation, and we offer an alternate position. And it is our belief that the child should benefit from intervention of the state during the child's development. And we also believe, flowing from that, Chairman, that there is some clarity that is needed in defining the commencement date before the referral to the child diversion program can take place. So we noted that the Ministry of Justice put forward that suggestion, that proposal, and that is something that we are also on board with as well.
Maybe later on you could tell us how we work with that gray area. You see, that gray area is where CISOCA or CPFSA or the Ministry of Education, they take care and welfare of the child. Yes. The child has committed no offense. So there's no basis to take it to child diversion. Yes. But the child has exhibited behavior which indicate that the child is on the brink of committing some offense and really needs, the support, mentoring of what we offer in child diversion. So, in truth, we have been wrestling with the idea, at what point should we wait until a child gets into conflict with the law before child diversion comes in? And we have seen, as indicated by the children's advocate, that many times, because the court have now got into a situation where they see that child diversion is working, there are many youngsters who are out of control, and the courts basically say we send it to child diversion. And to be fair, we're not doing too badly in terms. There are some challenges, especially because, especially the older offenders, they feel that they haven't committed any offense. And don't joke, they know the law too. They're literally saying to the child diversion officers, but I've committed no offense. Why am I with you? But to the extent that they consent and they agree, we have been fairly successful with them. So what I really want to, later on, before the day is out, how would you deal with that gray area between CISOCA, CPFSA, where no offense has yet been committed, which the child diversion is really taking them on when the offense is committed. But we're trying to anticipate that before an offense is committed, you get them the support. So sorry to interrupt, but you see what I'm getting at?
Yes, certainly. Okay. So additional proposals from the ministry is with respect to section 14 and I'm sorry, Chair, before I proceed to section 14, continuing from section 13, our position is that there should really be a proviso in the legislation to ensure and adequately capture that a child is afforded 3 referrals. And so we have an appreciation of what the legislation currently provides for, but we believe that there is some a greater need for clarity as to at what point those referrals would need to be engaged. And so, for example, if a child commits an offense in 2026 and successfully completes the program, then this really ought to be considered as a first referral. And subsequent completions of programs thereafter would then be treated with as the second and perhaps the third referral. So to have a discrete time frame that would allow for a more determinative factor to guide one's assessment as to when referral actually takes place, considering that a child is allotted 3 referrals. Okay. And so with respect to section 14, the ministry notes the benefit from the recommendation advanced by the Ministry of Justice in terms of provisions of reports to the police and to the court coming out of the child's involvement in a child diversion program. And so we believe that there ought to be further discussions on how this would be operationalized, taking into consideration key privacy issues, because these are matters that we would not necessarily want to follow a child into adulthood or prejudice the child's, prejudice the child's life. So to speak. And so where it is that a child participates in that program and a report is generated, we believe that there really ought to be some strict discussions and guidelines as to the privacy of that report and the sharing of the report with the police and the court. And so we raise that for discussion. With respect to Section 19.2, a child's failure to comply with or complete a child diversion program, the ministry is of the view that, and we take an alternate view to that of the Ministry of Justice and Constitutional Affairs, in that I believe the ministry raised a question as to what would happen next where a constable elects not to charge a child where he fails to complete the child diversion program. And it is our view, and I'm certain GCF may lend some additional discussion points surrounding this issue, but it is our view that once the child, once the officer exercises his discretion and elects not to charge, then that child ought to be released.
But we didn't take a different view. You're saying that it's alternatives to our position, but we didn't take a different view. I mean, if the constable has referred the child to child diversion because of some infraction, and the child goes through an appropriate child diversion activity, then the child should be released. You're saying that we took a different view?
No, well, Chair, I think what the Ministry of Justice had indicated was an appreciation for the child still being at risk of a delinquent behavior where they have not successfully advanced.
No, when they have not successfully complete the program and is still appearing to be delinquent, then, I mean, in other words, assuming the child has gone through a child diversion program, 3 months, 6 months,
right,
and the position of the ministry is that the child has not successfully completed the program, then it is the JCF that makes the decision. You know, the JCF can decide whether not to further the charge or to take it, recommend a prosecution. But we have no control over that to the extent that the JCF is the one that would make the decision. I mean, if it is successful, all clear.
Yes.
But if it is not successful and the ministry is saying, we have tried, but it seems as if the child is still susceptible to rowdy, delinquent behavior,
right,
and therefore we can't sign off that the program is successful. It is for the JCF to make that decision, not us.
and that is our position as well, that the discretion at that stage ought to still reside with the officer.
Absolutely. Yeah. I mean, you know, the child may have been found smoking marijuana, for example. But during the child diversion program, we appreciate that the child is still engaged in that activity.
That behavior.
So at that point, the constable may well say, we're taking that child to the drug court. And so the drug court may have another regime to deal with that sort of behavior. But, I mean, we in child diversion would have to report that that activity has not been curbed, you know.
And the ministry takes the view with respect to Section 22(4) of the legislation. We have taken note of the Ministry of Justice and Constitutional Affairs recommendation to include an age verification process, which will allow the police to be certain that a child is actually, that a child offender is actually to be treated with under those circumstances. And it is our view that we think regard or sufficient regard could be had to the police's exercise of their due diligence. And in those activities and in the conduct of their natural investigative processes, it is our position that that verification would come out through the police's interrogation of the person that they have before them, before a decision is taken.
That's appropriate.
Yes. And so, just to be clear, Chairman, it is the ministry's position that the age verification process, there would be no need, particularly, to include such a prescriptive requirement in the legislation for there to be a verification of the child's age.
No, I mean, we wouldn't want to put it in the legislation. Overall, the legislation is looking at offenders between 12 and 17.
Correct.
So you don't want to say it must be verified.
Right. So this would be our position in respect to the discussion around this matter coming from the Ministry of Justice and Constitutional Affairs. And also, Chairman and members, the ministry has proposed for consideration and further discussions, not necessarily legislative amendments, but several other key areas of concern. And I will lean on the discussion also, or the contribution of my colleague from the DCS, Mrs. Stephanie Roper, with respect to the expanding role of the juvenile correctional institution. And it is the position that the correctional institutions should have standing in, at the very least, recommending a child for consideration to a diversion program once the offense falls within the prescribed schedule.
But, sure, once a child has been charged and it is within the diversion program, Dan says yes. The problem with some of these charges, they may well be for serious offenses, which might be outside the child diversion regime. So a child may well be charged with shooting or, murder. That is really, unfortunately, outside the child diversion program. So if the juvenile institution has that child, the likelihood is that even if they want to recommend, it would only be purely administrative, but it is not. I'm not too sure. You're saying that, I mean, the effect of it, I don't think that child diversion officers would mind assisting the child. But at the end of that mentoring and so on, there's not much that can be done because the child has been charged with a serious offense. You see? You want to say?
In fact, there's a particular one that is well known. Little boy is only 11. He never shot, but he allegedly took a gun to school. And here's a child who never did any shot, fired any shots, saw something, his reports, saw somebody put down something under a tree, takes it up because they are, inquisitive and it carries a lot of excitement now, gun and that sort of a thing. Takes it to school and ends up being charged and has been properly traumatized. And even after he got bail, I mean, I have had difficulty with the Ministry of Education. I've called, and our Minister of Education is excellent, but I've called several education officers in the area to take the child in school, and they won't take the child. I had to put him on a bus, and he traveled from Ocherias to Montego Bay to go to school because of the stigma attached. And really, there's nothing you can do because the seriousness of the offense takes them outside of the child diversion.
And this is member, is a dilemma that we will be facing the child diversion program.
Yes.
Because the child diversion program at the moment doesn't allow. But there are instances where, welcome Minister of Education, and I must tell you, I mentioned earlier the problems that we have seen over the last few weeks. And how schools, unfortunately, Member Dalrymple, I just wanted to address it. How schools, unfortunately, deal with these offenses, where a child has committed bullying, some offenses, is to suspend or to expel them. And then the burden is on the parents or the Minister of Education to find another school to put them. So I'm really thinking, if CISOCA or CPFSA can't deal with that, is it possible, I was discussing with the team earlier today, could we find that if they went through a program of child diversion, that the school, instead of suspending them indefinitely or expelling them, that we could give a sign-off to say that, that child who has committed an offense in the school, it might be a minor offense, it might even be a serious offense, which you can recover. Because the way I'm seeing it, Minister of Education, is that where a child has committed a serious offense, any offense, I'm not too sure a child under 17 should be abandoned. And the impression I really get at the moment is when you see how schools, and I'm telling you, I've had to deal with a young lady who was expelled, and I had to beg a school that I have some contact with to take on that child. And, we as a community to watch the child, I asked the headmistress to watch that child. And so far, the child is not doing too badly. And the question that I ask myself, the way, unfortunately, far too many schools deal with it, is just to expel them. And I think something is amiss there. Sorry.
Thank you, Chair, for that question, and I have to apologize for being late. There are a lot of meetings happening at the Ministry of Education. But the point that you raise is important, and from a policy standpoint, we never abandon any child. We do recognize that in many of our schools, they take actions that in the ministry we don't necessarily agree with. Every child is important. Every child deserves a second chance. And that is our position. Now, we understand that there are rules in each of the schools, and for other purposes, it may need a suspension or it may need an expulsion. But whenever that happens in the ministry, our priority is to get the children in other schools. I mean, we were even speaking about starting to look for schools for some children who have been recently in the media and so on. So it is our policy to find another school in those instances. But the point that's raised in terms of working with these children is absolutely important, because in many instances, and we don't talk about it enough, there are things happening in their homes, in their communities. They're suffering from trauma, and these are the responses that we're getting. And so what is needed for these children, which is where we go to our therapeutic centers, is that kind of support where they and the parents, remember, it's not only the children, it's the parents too that often need the support, where we can have those centers available to do the counseling. But no, rest assured, Chair, when children are identified as having difficulties, there are psychosocial avenues available for them. One thing that many Jamaicans do not know, in the Ministry of Education, we pay several psychiatrists and psychologists on retainer. We have them across the country. So any child who is having issues, we pay for their therapy. and the therapy of the parents. It's not used enough because we've stigmatized getting therapy. But we have therapists across the country that can work with our children. But I'd love to speak with you separately in terms of how some of your programs could help. And the Ministry of National Security is helping us a lot in our schools too. We have school safety officers that are there. They are working with the children who are exhibiting some antisocial behavior, and they know them well. I've gone into some inner city communities, and the police officers are there, and they name me the children that give them trouble and what they're doing with them and how they're interacting with them. So there are a lot of agencies working with these children, and I think we must never give up on our children. And that's our policy in the Ministry of Education.
Thanks, Minister. Mr. Buchanan.
Chairman, I'm only participating in this particular situation because I'm familiar with this matter and I have been searching with the matter. We must be careful how we fit children into the legislation when it doesn't belong. My friend would have said that the child is 11, the age of criminal responsibility is 12. I've been looking because I don't know who to write as yet because I haven't even identified the child, but it's a serious concern because the child is being treated as if they are even competent or fit into the law in terms of criminal responsibility, is being treated as a criminal, is being sanctioned as a criminal, and even the school, hearing that a school would have expelled the child, kind of runs outside of what the child diversion legislation doesn't fit them currently, and the whole procedure is possibly ultra virus to the Constitution, to the Education Act, all of that. We have to think of that. So identifying these persons and intervening, it may possibly be at some point that institutions are acting outside of even their authority to do that.
A good point, Member Buchanan. Once the person, our age of responsibility is 12. So if the child is below 12, they should never be in a court. Should never be in court. So in other words, 12 is the age of responsibility. So that once they're age 12, they can be brought to court. But in fact, what we are working on, as you appreciate, is between 12 and 17, even though they can be in court and can be charged, we are hoping that we will treat them as if they were under 12. One final point, Minister Dixon. You were not here the last time, but there was concern that after we changed the law to remove uncontrollable children, that the law provided that there should be therapeutic centers. And they were saying that they are not too sure if these had actually been put in place. Mm-hmm.
All right, so they're not in place as yet, but the locations have been identified, and we have allocated funding from this budget to fix them. And so in another few months, we'll actually have our therapeutic centers, and remember there's also therapeutic places of safety. So there are two different things that are required under CCPA, and we've committed to making those a reality.
That's great news, because at the last time that was a major concern, that all of these children were being put into institution and referred to child diversion and so on. And as you weren't here when I said earlier, but I think it's clear, all the agencies of government need to work together. You know, everybody seems to want a firewall around what they're doing. And, you know, that's not the appropriate approach. We also have for child diversion, a number of children, psychologists. So between CPFSA, CISOCA, we just need to just pull together in the best interest of the child.
What I've been saying, that there are a lot of things happening in justice and obviously in education too.
Everywhere.
But people don't know. We're not aware.
Right.
You need the PR.
Are you finished, Rochelle? No, go ahead.
No, Chairman, just a few other proposals for the committee's consideration. With respect to data and record keeping, We note that the legislation currently provides for secrecy and confidentiality for all officers involved to have regard to. And it is our position at the ministry that perhaps consideration can be given to a retention, a record disposal, or destruction mechanism. And this is...
No, sorry, go ahead.
Sure. And so, although we recognize that there is this inherent need in the legislation for confidentiality, we would not want a child to be unduly prejudiced and for those records to be held against that person. And so it is our proposal that perhaps for your consideration, there could be some mechanism around treating with destruction of the records.
Excellent point. In fact, Mrs. Brown-Blake introduced us to the fact in another session, in another arena, that, and a lot of us are not even aware, that when, even for an adult, when a fingerprint is ordered for you, at the end of the case, if you're acquitted or the case falls out, the courts ought to immediately make sure that that fingerprint is destroyed. That has not been happening because you're not even aware of it. And I thank her for bringing it to our attention, because that comes to the point where somebody is charged for something, they're acquitted, and 30 years later, it happens when you're young and you come up and now you're applying for a visa and you need your record. And when you go to the record office, you have a record because your fingerprint is there. So that is something that needs, so that our courts or judges or lawyers, everybody understands. And now you're addressing it as it relates to children. And I think it's excellent because, you see, something happens and the child gets to a point now, teens or early 20s, and that same offense comes right back to hinder them. So I think that it is an important point, and it is something that we should make sure that we take on board.
There we go. So the ministry has taken note of some of the discussions in the committee with respect to the treatment of uncontrollable children, and we just want to note that we are in agreement with the position to treat those cases, to isolate those cases, so to speak, and treat with them more appropriately under the Child Care and Protection Act. And so we just wanted to add our points on that as well. And we also would wish to emphasize that there really ought to be consideration for removing or juveniles or children from juvenile facilities or correctional facilities, and treating with them more appropriately in a designated place to advance the therapeutic programs I know CTD would have made reference to early on in the presentation. And so additionally, if you'll permit me just to say a few short words on the treatment of children under the firearms, or children who have committed offenses, firearm-related offenses. It is really our position that this falls outside of the scope of the Firearms Prohibition, Restriction and Regulations Act. Even when we look at the legislation, it points you in the direction of the Child Care and Protection Act in Section 100 to treat with those cases specifically. And so it is our position really that the firearms matters really should be kept separate. They are egregious in nature, and it goes against really the spirit and intention of the legislation. So the recommendation, Chairman, is really that it ought to be kept separate.
You think it
having
is
regard to the
you think it is something that the DPP, for example, based on the circumstances, could refer to child diversion and then make a decision whether or not to pursue the charge? Based on the circumstances, in other words, if it is a child, I'm asking you, what's your recommendation?
The position in respect of that case really depends on the circumstances of the
No,
matter.
yes, absolutely.
And we certainly believe that the DPP is an authority properly placed to consider the gravity, the nature of the offences,
Right.
the gravity of the offences. But we think that we think there is scope for the committee's further discussion and consideration of those points, Mr. Chairman.
No, but we would want to hear your recommendation. Let me put it this way. Obviously, we have to appreciate the DPP as a constitutional officer will have to be accountable for anything that is not charged. So can you imagine a youngster commit murder and the DPP say, no, that's child diversion? That's unlikely. You know, the DPP would really want to take that to court. You're serious offenses. But let us say the DPP had a case where a child was found with illegal possession of a firearm. And the child explained how it came about. Would you recommend that the DPP should be given the authority to be able to recommend that to child diversion? Why I'm saying so, at the moment, is only specific offenses that the DPP can recommend to child diversion. But considering that the DPP is a powerful office, if they see circumstances where they really should not proceed, but it could go to child diversion, would you recommend giving the DPP a residual power that in other offenses outside what is in the Child Diversion Act, he or she could exercise their discretion? I mean, the point about you're going to come in. Sorry, JC, go ahead. You want to?
All right, thank you, Chair.
Go ahead.
Okay. I believe that is something that we could support, properly built out, because whilst the standard is that we do not believe that any firearm offense should be a diversion offense. That's the standard. That's ground level, right? That's a starting point. However, we appreciate that children, unfortunately, might find themselves in certain situations that working with a mandatory minimum might be quite unfortunate. So in those circumstances, we agree with the referral to the ODPP for them to assess the allegations, whether there was truly intention to possess and certain kind of things, and then make a ruling that is appropriate in the circumstances. But I just want to ensure we agree that it absolutely cannot be a diversion offense, but the ODPP is a proper party, and I think that that office has, should be empowered to make that kind of decision. If I may, though, Chair.
Colleagues, this is something we need to consider. Sorry, okay. Finish up.
All right, no, that's it. I was going to yield to SP Henry, but he says I've covered his point.
SP Henry, you want to say something?
No, I'm saying the point was covered by Mrs. Brown.
Okay. Go ahead, Member Buchan.
So I'm addressing Ms. Jagon and Ms. Brown-Blake, because where child diversion is concerned, we're actually starting with the best interest of the child. We also have constitutional implications where we have equality before the law, and there's equity implications. The DPP, as a creature of the Constitution by virtue of Section 94, she has wide powers. But just on a practical plane, because there is a term that was coined in this very room, the lived human experience. We've had mentors that speak on the interaction with the child in particular. But when we speak of firearm offences and the approach you're taking, the best interest of the child is demanding of us to treat our children in Jamaica as children, without offending anyone. If we start with the best interest of the child, what would be the difference when we're talking about possession simpliciter as a scheduled offense between a child in possession of a knife, a child in possession of a chair which is available at schools? This is in the context that there is recently, while the child diversion committee has been sitting, a child has hit another child over the head with a chair, resulting in death. This very week, I've had to look through social media, hear the learned minister address issues where a child used a knife to unalive another child. How do you exclude? Yes, I'm being hip. TikTok. How do we address the issue when it's possession simpliciter? And I have to say it here that children are children. We all sit here and know that a child cannot buy a gun. I'm starting right there. And yes, we can have discussions about levels of competence when you get to 16, 17 and them think them ton man and big woman. But treating a child as a child, that's what the basis of child diversion is. So Ms. Brown-Blake said that it's like non-negotiable from the JCF and the Ministry of National Security. But if we are in the business of diverting the basis of the spirit of the legislation, when it comes to the simpliciter, where is the compromise and the power we ought to be giving the DPP if it is that the first person, which is the officer, may be uncomfortable with saying that it actually is beneficial, because if the children were actually found in possession of the guns and simply had to hand it over, and let's address the elephant in the room. There are gangs using children to lock guns. But they are victims, They are victims of circumstances that we have to step in. It is our duty, the best interest of the child, child care and protection. But I'm leaving it there because I just want a response to address knife, chair, objects that can unalive people versus possession simplicity.
This is a social media term, unalive.
Unalive, yes. You won't get blocked.
This is new to me. But Member Buchanan, I think based on, and JCF we will bring in on very shortly, but there should be this residual power in the DPP to look at using the DPP's discretion. And we expect the DPP to exercise the discretion professionally. I mean, there are some offenses. If the youngster is a gang member, the likelihood is that they're not going to, send them to diversion. But the circumstances will have to be appropriate, as you'll appreciate, for the DPP to not to charge.
Chairman, I'm just simply saying that I know how we as a nation feel about firearm offenses, but we have to confront the fact that children are children. Absolutely. And how we want to treat our children. There must be some equity. So we don't want a situation, even with the DPP and the residual power. I'm just simply saying it's a matter to consider collectively, but is it a case where we are including possession simpliciter as a schedule offense,
we're not going to
or
put
not?
It, no,
I don't know. I'm just saying it's a conversation to have.
I wouldn't say we put it in the schedule, but we should give a residual power to the DPP
to consider
in appropriate cases, whether it is drugs, guns, carnal abuse, in appropriate cases, not to charge. Obviously, the DPP will have to weigh the other, not only the circumstances, the other public interests.
But judges have that power currently.
Absolutely.
So if we
give
the DPP equal power, then that question is answered by virtue of allowing the DPP under that section, the residual
That's
power.
the point I'm making.
Yeah, I agree.
But she would have
Chairman.
to balance between the interest of the child and the public interest. Because the public interest may well dictate we should proceed. Okay. Sorry, continue. You wanted to?
Right. I just wanted to make a quick comment because I understand members' point. However, it's twofold. So one, I think the balance that is created is having the ODPP review the matter and make a determination. And from a police standpoint, we have a discretion to prosecute or to not prosecute, and the case law is clear on it. In fact, SP Henry was just recalling a situation where a man, well, I'll give you the opportunity, but pretty much we have the discretion. So we assess the circumstances, and it's the same thing that the ODPP would do. So I think that is really the striking of the balance, and why firearms have to be treated differently from the stabbing, etc., etc. I mean, we look at the memorandum. I was just glancing through the memorandum of objects and reasons for the Firearms Act, and we know the standard or the state of firearms in the country and how they contribute to serious and violent crime. So we have to treat it differently than just a stabbing. We know the prevalence and we understand the prevalence. So we have to treat it differently, but the balance is struck with the ODPP.
Right. Thank you, Ms. Brown.
Thank you, too.
You want to finish up?
I think we would have ventilated the totality of our
But remember, we're coming back to you with the grey area. I know the JCF is under time pressure, so I'm going to take the JCF at this time.
All right, thank you, Chair. Okay. All right, so do you have our presentation, Sir Nash? All right.
You're going to do it, Ms. Brown, or you have a superintendent deal. Who is dealing with it?
I can check. Okay. I will be dealing with it, but I'll be supported by Mrs. Jamie Brown Bailey, SP Kenil Henry, and SP Carrie-Ann Bailey.
Well, you go ahead and lead, and then you can.
All right. So, want to? Okay, great. Let me just give Mr. Nash 30 seconds. Okay, good. Oh, okay. Can you move it on? Thank you. I crave your indulgence, Chair. Just give us 1 minute. What is it's right there? That's my question. It's on. Okay. Thank you.
Alright, you should be good now.
Okay, you okay now? Mm-hmm. Turn on the mic.
All right. So, just let me know. Okay, great. All right. Good afternoon again, Chair and members. And thank you again on behalf of the JCF for the opportunity to share a practitioner's perspective with you. As you well understand, the legislation contemplates two parties that can refer. a child to a child diversion program, one being the police. And so our presentation this afternoon is from our practitioner's perspective, and at times I will yield to the views of CISOCA and CSSB. Please, members, feel free to interject me if you have practical examples, as I'm sure the members here would benefit from your experiences on the ground to help you understand our lived reality. All right? Good. So the very first thing, search here that, well, I did the introductions already, so permission to skip that. I went through this just now. We play a central role in administering the act, particularly in determining whether a child should receive a formal and informal warning, formal warning, caution, and or referral to the program that we are here to discuss. So we have about 8, I know it sounds a lot, but we have 8 submissions. I'll do my best to keep them brief. The very first one that I want us to consider is that in our experience, the first schedule is limited, and because of that, we are asking the committee to consider adding other offenses. Now, I know that there is a catch-all provision in item 10, which says any other offense under any legislation that has, is it a term of imprisonment not exceeding 3 years? Right, but the offenses that we see most children coming in for, those offenses, the term of imprisonment exceeds 3 years, so they're not properly captured. The first one I want to bring to your attention is grievous sexual assault, and I think it's a matter that has been brought to the attention of the committee before. But our reality on the ground, and CISOCA will tell you, is that it is quite just as prevalent as sexual intercourse with a minor. And in fact, we're not only seeing grievous sexual assault with the use of digits, right? With the use of your body parts. There are other material, and that is our lived reality. And we have to find a way as practitioners to properly deal with the matter. But because of the spirit of the legislation, we don't want to put them before the court, because we believe, just as Minister said, that every child, their best interest should be at hand. However, we are constrained to bring them before the court. No, and some of them are curious, testing out things, etc. And the right place for reform may not be the court in those circumstances. Another thing that we're experiencing too is that they may come before us for a divertible offense, right? So maybe a sexual intercourse with a minor or an indecent assault or any other offense under the first schedule. But with it is also the grievous sexual assault. And we can't refer them to diversion, even though there's a divertible offense, because it is paired with the grievous sexual assault. So we have to put them through the court. And as you understand, that goes against the spirit of the legislation. We want to give the children an opportunity to be reformed in a way that doesn't let them reach my friend at the DCS, right? Before we reach the DCS, we want to put them on a trajectory for reformation, and we can't do that. The other offense that we are seeing quite a bit of, especially in the day and age of the same TikTok that my friend referred to, and other social media, I don't know if there's anything more popular than TikTok now, is an offense called malicious communication under the cybercrime.
Called what?
Malicious communication under the cybercrime legislation. Now, Chair, being, the internet platform has given a lot of persons, both children and adults included, the opportunity to be big and bad and bold and brave on an online platform.
More bullies.
More bullies. So that is exactly what is happening. So we see children, a lot of children being bullies, and sending obscene and threatening material to other children using an online platform. When they come into us and we detect that offense, we cannot refer them to diversion. We have to put them before the court. And many times when they appear before us, their tail is between their legs. And a child like that, so afraid and showing apparent regret, we think could be properly dealt with by diversion instead of putting them before a judge.
But let me ask you though, wait, Ms. Brown, remember now, the DPP came before us last time. And basically, once the DPP recommend or the prosecutor recommend diversion, rarely does the judge say otherwise. So what you're saying, the constable may not want to take on that responsibility and may well want to refer the matter to the DPP. Would you agree that we could go to the route which you were just suggesting, that the DPP then has the discretion to see if the child, go through the child diversion, and then if the child doesn't perform properly, but what you're saying, Superintendent, you'd want the court to deal with it?
You know what?
One second.
I would recommend that. So we have sexual intercourse with a person under 16, and you have 2 15 years old engaging in the same kind of behavior, which is grievous sexual assault. So we're looking at it to say if you have sexual intercourse with a person under 16 and looking at the circumstances with grievous sexual assault, it could also be provided there, and we deal with it at that level rather than going to the DPP's office. That's a proposal.
Well,
looking at the circumstances of it. Because what we currently do, we still engage with the DPP's office, depending on the circumstances of the case, to determine whether or not we go with a particular course of action. And we contact the DPP, and DPP will recommend that it goes before the court and recommend to the Crown Council that it goes to child diversion. And sometimes what you find, Chair, is that 2 15 years old engaging in this kind of behavior, girlfriend and boyfriend, as they call it. And the parents are saying, all right, we can agree that whatever it is. So rather than putting it to the court for the DPP to make that decision, it could be there for the police officers to deal with it. That is the submission.
Right. So what we're really saying is, always the public interest overrides, the best interest of the child. But when you take the best interest of the child, are there occasions where you think that you shouldn't charge? Yes, the public interest always overrides everything. And public interest must override everything. So I'm not saying that the best interest of the child should be taken into consideration, but when you balance both of them, the best interest of the child can't override the national interest or the public interest.
Chairman, respectfully, the public interest and the best interest of the child is the same. It is the interest of justice that the DPP will grapple with. But I don't think, especially in private matters, so I don't wish to be the lawyer for for the JCF at the moment, but to say that that is a power, I think they're best, especially when dealing with cyber crimes and sensitive matters like that. I don't think that's a public interest as much as it is so private that they are the best person to minimize the exposure. If we were to take the cyber situation, the JCF is well equipped to take down the publication, censor the conduct, and then it would reduce the opportunity to have to place this thing on DVDs for persons to review. These are children, and the privacy is important.
No, but what I'm saying, Member Buchanan, the public interest may well require that the matter be dealt with publicly. You take, say, you have a child engaged in scamming, because the public interest dictates that we want to get rid of scamming. It may well be in the interest, the public interest, that the child be charged, and that it matter come to court.
No, so Chairman, this is where I have to depart, because children are treated with in camera every time that children are before the court.
No.
Especially for sexual matters, the matter is in camera.
No, I accept that, So the point I'm really making, yes, Member Buchanan, is that in many instances, when you balance the public interest and the interest of the child may well be a priority, because the public interest is not that affected, if you understand. But if the public interest is so affected that you need to get rid of that sort of behavior, then the public interest has to come first. So I'm not denying, but at the end of the day, the interest of the child could be priority because the public is not aware, the public is not affected, and so on. But where it affects the public interest has to come first.
Very,
right.
Very well, Chairman. I think it's a point that we can discuss as a committee, definitely.
But may I ask the superintendent, because you were saying something and I'm not too sure that I get the gist or the full impact of what you're saying. You were saying that, say, 2 15-year-olds engage in consensual sex, that the constables sometimes haven't talked to the parents, that they can, sort of just warn the children and without charging them?
We wouldn't charge in that case. We'd refer them to the Child Diversion Committee.
So I don't have a problem
Right.
with that, you understand?
Right.
But to the extent you see that, this is where I feel the DPP should come in, because the DPP is the authority who would say, yes, the law has been broken. But that's something we need to just discuss. And I agree that the constable should be given the discretion as much as possible, especially considering the circumstances. And also, the DPP. Because at the end of the day, as Member Buchanan will emphasize, the best interest of the child is to keep the child away from the court proceedings. You understand? And that I agree with. You get me? So, sorry.
I just wanted to ask a question. You mentioned the real close in age or the same age. Do you look at a situation where the age might be a 15 or 16-year-old and an 11-year-old or 12-year-old? What then, how would that situation then would be handled? I'm very curious about that.
It all depends on the circumstances of the case. Again, we do an assessment. When you have a 16-year-old versus an 11-year-old, then more than likely the parents are called in, they are spoken to, and sometimes we'll refer the case to the court, and the court makes the decision based on the circumstances.
I must tell you that the churches are of that view. The churches feel that you should refer the matter to the court or the DPP, and the DPP or the court can make that decision. But what's your view? Let me get straight to it. Close in age, removing the law so that close in age is no longer a criminal offense. In other words, we're not talking about under 12. We're talking about 12 and 15, 13 and 17, 16 and 18. What's your view? Do you think consensual, non-consensual crime, but what do you think in terms of consensual sex? Do you think we should remove that from the statute book, or we don't criminalize that behavior? Yes, just press the.
If I may, I think that's where we are looking at, and coming up in the presentation, you'll see where we have a slide for submission where we have two 14-year-olds are 14 and 15 or 13 and 14 who consent to having sex. And they usually, for us in our experience, is that the female child is brought to us first. And this in most cases has to do with either the incident happened either at school and they're referred to from the guidance counselors or the school administrators, or you will find that the child is now pregnant, or the parents may have stumbled on probably text messages or some messages to see that they are corresponding and so on, or if they find that they have contracted an STI. So usually it's the female child that is brought in by a guardian or parent. And in that case, when we do the interviews, they usually tell us, it's my boyfriend, or we had decided to go meet at his home, or when the parents are not there and there's an agreement. And in some cases, it's the female that's actually the initiator of the encounter.
Boy, them getting bad.
Yeah. I don't know if Ms. Brown-Blake mind me jumping right to that here. So since I'm already there, what we find is that based on the act, it's the child offender that is referred to the diversion program and not the victim.
I think though, I would like, even if we change the law, that there's an opportunity for some of these children to get counseling.
Yes.
Very important, because in not charging them, we're not saying they're doing anything right. They should be told that what you're doing at that age is not appropriate. So to the extent that we want to be able to frame the law in such a way that a constable can not only give warning for behavior that is not necessarily in conflict with the law. At the moment, it is in conflict with the law. But if you remove that from the law, we'd still want that sort of behavior to be for the constable to warn them and to let them know that if that continues, there could be a consequence, as the case may be. So it is something that we know we have to grapple with when we get back to Parliament. Okay. Sorry.
One of the points that Ms. Bailey made, that I think we have not looked at, is the practice of 14 years old. Mother takes the girl to Sissoko or to the police station and reports it. And they're looking at the boy as if the boy is the offender, not the girl.
Yeah, this is what I'm...
So it is a picture that is painted as if the boy
is always the one who is the...
and not the girl who is the offender. So what we have been doing is to have both of them, because if it is that both of them have offended, as a consequence of that, you find that the girl's parents usually wants the boy to be charged. Mm-hmm. So I think public education is required as it relates to how we treat with those cases, to say that both of them are victims and both of them are offenders.
Quite.
So that they understand what they are required, because it requires the consent of the victim, the informed consent, and they tend to not want to give the informed consent for the boy, the girl's parents.
Just for fulsome understanding, there are persons who will say no girl under 16 can consent. So it's almost an anomaly, they're saying, to say that the girl has consented. Right?
Yeah. I wanted...
No,
I want us...
lawfully, legally, right?
Chairman.
Mm-hmm.
Oh.
Go
Chairman,
ahead,
if I may, and that is something I was going to ask, who would then be the one that would be sent to child diversion?
Both.
I would say both.
Mm-hmm.
Another thing is, if it is that a parent, I'm concerned that maybe if a parent wanted for the boy to be charged, mm-hmm. I'm now wondering what would happen if it's in law that both would have to go into a child diversion program. If it is that it's now going to be, well, no, both should be charged. Right, I agree with that. I'm now wondering if that is the case, that if both are not charged and only the boy is charged, will now the parents, will they then, well, report it? Would it now be reported, or what would happen in that situation? I'm a little bit concerned as to how that may play out by the parent not reporting it for whatever reason, because they think that no, the girl would not be charged.
Minister Dixon.
Chair, I have a different issue, and I'm waiting for when we can meet as a committee, but I'm raising it here. I have a serious issue with close-in age sexual activity resulting in charges. have a serious issue with it. I think it needs to be dealt with. There's sexual education that needs to be done. There are other avenues to treat with it, but the notion of it being you getting charges for it is a concern. But I know we'll have other discussions, but that is a key issue.
To be frank with you, Minister Dixon, we went through this in 2017. And the recommendation, for one reason or another, we have not brought it back for the law to be changed. But it is something that should be done soon. Okay? Thanks again for the... All right, Ms. Brown, please, we have interrupted you, so we want you to complete.
I wanted to piggyback on something that Ms. S.P. Bailey said, since you have completed your submission on this section?
You want her to...
Oh, when we get there, all right. I will leave it until such time. But what I will go to next... All right, so that's the sum total of the first discussion on additional offences for the first schedule, diversion offences. So the second thing that I want to talk about, I'll yield to S.P. Henry. I'll yield to S.P. Henry and allow him to talk about or issue with the definition of child offender and the fact that some of the things that we're seeing in practice we are unable to deal with because of certain limitations. S.P. Henry.
All right. Thank you. Chair, we have an issue, and it came up earlier in this committee meeting. Children under 12. So we are seeing reports where an 11 years old and a 6 years old oral sex. We are seeing, yes, and when you interview the child is saying that it's the environment that they're in there. I've seen it. We have another case of a 9 years old and a 4-year-old.
Wow.
So I know child diversion is looking at real child offenders' criminal responsibility. So I would make the recommendation if we could have consequential amendments to the Child Care and Protection Act when we have those kind of cases. Because I've looked at the UNICEF systematic responses to children under minimum age of criminal responsibility who have been involved in offending behavior. So there is a document that was published December 2022. It's almost like child diversion, but they call it special measure. So those children, they cannot be charged, but you have something like diversion to expose them to. So I'm wondering if provisions could be made to treat with those children who are under the age of criminal responsibility so that they could be placed on programs so their psychosocial welfare can be taken care of.
You know, the Superintendent Henry, although I'm not disagreeing with you, it's the parents who should be charged. No, I mean, in all sincerity, 4, 6, 9-year-old, no, with due respect, these children need care and protection. And I think somebody had mentioned a parental order. These are children where you should have a parental order against these parents, because what do you do with a 6-year-old child? I'm not too sure what you can do, Superintendent Henry, even if they go to child diversion. I'm not even too sure what could be done by the child diversion. These are just children who seem to need parental guidance.
Chairman,
one second. Let the Superintendent Henry and then you.
In these cases that we have picked up on, is not the 6 and the 4 years old. They were victims. They don't know anything about it. It's the 11 and the 9 years old, and they were not exposed to it at home. They were exposed to it at school.
Then the teachers should be responsible.
So it's the environment. So it's the environment as well. So we have to look at it holistically and look at these children under the age that are being exposed to these kind of behaviors and they are practicing it. So sometimes, yes, the parents ought to be blamed, but sometimes as well the parents cannot be blamed based on the nature
No,
and the
I understand that.
circumstances
If it's
of
happening
it.
in the school, then Minister Dixon, the police should bring these matters, the school where this happened, should be brought to your attention.
The first child that introduced it at school, they learned it at home. So in any way we look at it, a child does not wake up and learn this behavior on their own. They learned it somewhere. And that first one who would have introduced it would have learned that at home. So we have to definitely start with home. And if there is an issue at a school, I would hope that the JCF has notified the Ministry of Education on an issue like that.
Just let Minister, sorry, go ahead, Mr. Buchanan.
So, I've not seen the name in our show.
Henry, Superintendent Henry.
Superintendent Henry, you're on the right track. And you are 100% right. Is what is the object and purpose for child diversion is separate from what you are raising. I actually spoke to the Minister of State in Security, and I based on reading your the JCF document, at paragraph 1, inclusion of children below the age of criminal responsibility, the language is welfare-oriented intervention, and I think a simple answer would be the Welfare-Oriented Intervention Act, where we can consider parent orders. From this very committee, I think that there is a term that can be coined, the uncontrollable parent, and then we deal with the Welfare-Oriented Intervention Act so that they under the age, these children, whether it be 11, 10, 9, 8, 7, they don't have any competence in committing a crime. That's what the law says. And we have to intervene and hold them, similar to the Child Care and Protection Act. It's child neglect. They learn this conduct at home in the communities, and they're seeing things. If you're not watching the iPads and the cell phones and all of these things. And so it has to be a separate legislation, and they have to treat them separately.
I think Superintendent Henry, it's fair to say that these are matters which could be outside the boundary of child diversion. But I'm glad you bring it here, because Minister Dix is here, and Sissoko, CPFSA, they're here. But these are matters of serious concerns. And I think you know it's a matter of serious concern. And I'm glad you brought it up here, because these things, shouldn't happen. The question arises, and this is where the point that Member Buchanan is saying, in matters like these, there should be some basis for a parental order. But I'm not too sure this is the committee that actually imposes, under the Child Care and Protection Act, Member Dixon. We need to put some parental order in that legislation. Coming back to you shortly. Go ahead, Member. No, one second.
Thank you. Thank you very much, Chair. Just noting also that the CCPA is actually, we're doing drafting instructions now for amendments to CCPA. So that will be a joint select committee after this, because a lot of what we've been talking about here fall under the ambit of CCPA, where there is no criminal activity at all, but the children need care and protection.
Absolutely.
And they're exposed to a lot of things in our communities and in our homes. A lot of problems are there. So we will be doing this same joint select committee, and so I urge the presenters to identify what's really child diversion versus CCPA.
Yeah. Absolutely. I'm glad for that separation. Member Williams.
May it please you, Mr. Chair, but that's really my the point I was about to make, because I'm listening to the discussion and I was wondering if we were embarking upon a duplication of roles and functions, because if it is, for example, the example cited by Superintendent Henry would properly and appropriately fall within the Child Protection and Family Services Agency. So what we need to do, and as I'm happy that Minister Dixon has pointed out that soon and very soon we'll have legislation to strengthen so that we could, once we have this implemented and in place, what we would find out is that the Child Diversion Committee could properly handle matters that fall within the schedule and are criminally and carry criminal responsibility vis-a-vis, separate and apart from offences that other agencies can handle, and we avoid duplication.
The only thing I would urge, Member Dixon, when that Joint Select Committee comes up, or as I have been repeating, we need to work together. In other words, and that is why I'm coming back to Ms. Rochelle Jagan about the gray area. How do we make sure what you brought up, Superintendent, is very urgent. So I can see that that act needs to be adjusted to take care of the issues that you raised here this evening. We are under 12. Clearly, these are neglect, whether it is in the school or the home, and matters to be addressed. You can't rely on the police to deal with all these matters. These are matters that another unit of society, the home or the school, should be dealing with. And there has to be provision in the Act where, if it is a school that is at fault or the parent that the home that is at fault, that there should be some consequence that these children are falling into this sort of misbehavior. So thanks for that point. Inspector, you wanted to?
May, Chair. The member just raised that, these matters should be for the CPFSA. When they do come to us, when we have victims who are 4, 3, 5 years old, they are referred to the CPFSA. So that part is dealt with by them. If the child is 15, the child offender, or above 12, they go to the child diversion.
Right. But what I think Member Dixon and Member Williams are saying, once you do that separation, we need to know what is the consequence for those young children who are victims or, offenders. What is to be done? Nothing can be done or should be done to them. It seems to me it is the guardian or the adult that is supposed to be in charge of these children who should bear some consequence. Because these are children who are out of control. Yes, Superintendent.
Yes, I'm not looking at the consequence, really, and I'm looking at the child who engages in this behavior and what kind of system can we put in place to treat with this child. What psychosocial care, because this child is also a victim who we are calling, even though by law he cannot be an offender. But I'm looking at it from that angle as it relates to this child who has engaged in this behavior, is 11 years old. What do we do to assist this child who has come before the police officer and we refer the child to CPFSA?
And this is where CPFSA is the proper organ to deal with that. All right? Because I think.
So the procedure can be in the Child Care and Protection Act, but we just want to have it so it is dealt with because we're getting these cases now.
I think Minister Dixon is aware, and as she say, it will be dealt with hopefully shortly. Ms. Brown, you finished or you have some?
I have some more,
Go
Sir
ahead.
Chair. Right now, I will yield to Mrs. Brown Bailey, who will address another submission that we have relative to the prescribed forms or the lack thereof in the schedule. Good afternoon, Chair. And members. So we have a serious issue within the JCF. So there is a lack of prescribed forms in the schedule. So we are proposing that the Act provides for prescribed police referral form with a section addressing consent of both child offender and the victim. Such form must be aligned with the statutory requirement for the child offender's eligibility for the program and the consent of the victim for the diversion offense. We're suggesting that though that there is a form that is currently used by the JCF, it's not a gazetted form. There is a particular section as it relates to the police warning where it says that once a formal warning is issued, the police must issue the formal warning in a prescribed form. As such, we don't have a prescribed form, so that is not being used. So we are proposing that we have these prescribed form instead of the one that we have now, which is just a general referral form to the diversion program. The next one that we'll do, Sir Chair, is one that we briefly discussed earlier, but I'll allow Sissoko to give their unique perspective, as SP Bailey was referring to earlier, relative to matters where the victim is a child and the law does not properly make provisions for them. SP Bailey?
We started the discussion where we had close in age persons who agreed, to have sexual encounters. What we are recommending is for the Act to make provision for dual referral to the child diversion program for these persons, because as it stands, as I was indicating earlier, it's just that usually it's the male that refers to the program, and the female is the victim, and she usually gets counseling through Victim Services Division. And in some cases, when you have deliberations and discussions, we wonder sometimes if it is that the system is the one that actually victimizing, some of these children when they are experimenting and, there's an agreement. We believe that in cases involving sexual conduct between minors, both children should be afforded psychosocial assessment, therapeutic interventions, sexuality and relationship education, family support services, among other things. And this will ensure equitable access to support services for both parties, recognize that both children are vulnerable and in need of structured intervention, enhance early prevention of sexual exploitation, harmful sexual behavior, and reoffending, reduce the risk of trauma and maladjustment in victims, and to align the Act with modern best practices in child justice, including trauma-informed restorative approaches.
One of the things, too, that One of the things, too, that we found is that if it is that you have two consenting children, not that we are agreeing children, right? Two agreeing children. One, usually the male, is sent on a diversion program, and for whatever reason, they do not successfully complete the program. Might be a fault of their own. Maybe their parent is overseas, or maybe they are overseas and they're not able to complete. In any event, the committee lets the police know, look, this person has not successfully completed the program, and we move to charge them. Remember, what was the starting point? There were two agreeing children. So when we move to charge them, one now becomes the complainant or the victim, and that complainant / victim might have been the one who was the initiator in the first place. So I think accompanying that, the very submission is that the act or the wording of the act automatically assumes that there is a victim or a complainant when both parties really are the victim and both parties are the offender, right? So that's one of the things that we'd love for the committee to take into consideration, because when we move to charge the young man, the person who really was the initiator is now a victim or a complainant. We just have two more submissions, go ahead. Sir. I don't want to take up too much time from the committee. I think... Sure.
Good afternoon, everyone. Just as you said, right? And as regards to a minor, so we have a girl, a young lady comes, and she might agree to have sexual intercourse with a young man. So that young man is placed on the diversion program. So the next month she come back, and it's another partner she agreed to have sex with. So that young man is on the diversion program. And the other month she's back with another partner agreeing to have sex. And then we have 3 young men going to diversion, and she just go to the victim support unit. And so that is why we look at the victim against the perpetrator. Thank you. It is a true story. We only come here with true story from Sissoko.
You can't believe it, right? Okay, go ahead. No, I mean.
All right, so. Oh, here. Okay, good. So the next submission that we have for the committee is that upon our assessment, we've noticed that there is an absence of a centralized database that includes informal warning, formal warning, caution, and persons who have been referred to the program. So while internally within the JCF, our crime reporting and case management requires us to record every interaction with a child. However, it does not create a centralized island-wide database for us to check and say, okay, this person was a child offender in Kingston. In Westmoreland, the person let us say he moves to Westmoreland. The person in Westmoreland cannot check a database to say, okay, this person actually was in Kingston doing the same thing. This person was in Montego Bay doing the same thing, etc. And then, to tie it in, there is no general register of referrals that can capture this. So we are just submitting that there be a central database to capture all of those things. It could be holding with the ministry, and access be given to the JCF and the relevant agencies that partner with us for diversion.
This is a matter for the JCF. I mean, I'm sure you must have something like that too.
Yes, we have it. We have the electronic case management system, but the point that Ms. Brown-Blake is making is that at the National Diversion Committee level or the office, if it is that a child has gone on holidays in Westmoreland, commit himself there. He comes back to Kingston, he commits himself here. At the national level, we wouldn't be able to know that. The JCF, we are still in the process of our electronic case management implementation, so not everywhere has that particular database yet.
Synergy is working with you people.
Sorry?
Synergy. The database people.
That's right.
Okay.
Yes, sir. Yes, Chair. Yes,
so, well, what I would like to tell you, though, is that the court system or the justice system is shortly to engage them fully, and it will connect up all the DPP, the Constabulary Force, Correctional Services, Forensic Lab, and it may well be that we connect up Sissoko and others who are part of the, should I say, the security and justice system. Indeed,
yes,
we're learning from Rwanda, and we're having coming this weekend, a representative from Rwanda who is going to start to set up the system with Synergy. That's the name of the company.
I'm not certain, sir.
No, the name, huh? The technology company that, why don't I remember the name? It's Synergy. It's Synergy. Synergy is now working with the correctional services.
Okay.
Huh? Anyway, it doesn't matter. The point about it is, with technology now, there's no reason why there should be a firewall between information from the relevant government ministries. So we want to make sure that all the relevant government ministries are interconnected, even though the data is protected. But to the extent that all the relevant government agencies know what is happening in Montego Bay or in Port.
Exactly.
Right.
And that's what we're trying to achieve, because the legislation, I believe it is in Section 31, actually requires us to calculate how many cautions have been given to a child, etc., with the intention that, okay, there may be a child, or there might be a child who is a regular infractor in different spaces, right? And we, in determining, okay, should we give an informal warning or a formal warning or a caution or a referral, we need to be armed with the information as to what kind of history does this child have. So we support the work that Synergy is to do to connect all of us together. To close, Sir Chair, I will allow Mrs. Brown-Bailey to speak on expungement.
Not my thing, the ministry's thing. Government thing.
Well, it's certainly not expungement in the criminal record office You know,
no, I understand. I'm kidding.
But what this legislation categorizes as expungement.
You go ahead.
So the Child Diversion Act, Mr. Chair, gives the police the power to expunge from the register certain information relative to when they issue formal warning and caution. What is lacking, though, is that it says that it must be done in accordance with certain procedures as prescribed. There are no prescribed procedures. So we're lacking. So we're asking that such procedures be detailed in the Act, so we are guided by, because as is right now, we keep a localized register, and we have certain documents that are filled out, a referral form, and we keep those with certain statements that we collect. But as it relates to how we treat with those, in accordance to Section 29, subsection 3, we are seeking the guidance or clarity within the legislation. Interim Chair, if I may, just to support that point, the legislation actually only speaks to expungement of formal warnings. So if we log an informal warning or if we log a caution, there is nothing to say that should be expunged. So those things remain on our books to perhaps stay with the child for the rest of his or her life, and I think that is against the spirit of the legislation. The section starts by speaking about formal warnings and cautions, and then only makes one provision for the expungement of formal warnings. So we want to, in the best interest of the child, have the inconsistency remedied, and then explicit provisions for expungement. You know, member Minister Dalrymple Philibert earlier spoke about fingerprints, and one of the things to do with fingerprints is that when you are doing destruction, you're supposed to issue a destruction certificate. So I only use that example to say there are guidelines included as to how you should destroy and what proof of destruction, you should issue. Now, I'm not trying to require the police to provide proof of destruction. What I'm really trying to do is to ask you to provide us with a procedure so that when children come, or maybe when their adults come with their attorney to check our books, we would have been found to have complied with not our standard, but your standard. Mm-hmm. Yes.
Interesting you mentioned it. This morning I had a meeting with the expungement committee. First time, because we have some new members. First time I'm actually meeting with them to look at that very point where when persons take fingerprints and it goes to CRO, sometimes they're acquitted, or sometimes because of the age, the judge says no recording. But for one reason or another, the fingerprints are still at CRO. And it is creating a whole heap of problems for persons 10, 15 years' time, 20 years' time. You saw what happened in the newspaper with this man from 1995. It is a regular thing because the fingerprints are not destroyed. And that is why I will be meeting with the Chief Justice to deal with that matter. How do we deal where you give a fingerprint order at the beginning of a case, and nothing is done to destroy the fingerprints, and they end up at CRO, even when the person is acquitted or the case is thrown out. So it's a real challenge. Uh-huh.
Chair, not to stray from the matter at hand, but in another forum where both yourself and Minister Dalrymple Philibert were present, as well as myself, CRO had indicated that I'm happy you're meeting with the Chief Justice, because a lot of the times the orders are not passed from the court to the CRO. Well, maybe the order is not made, one, and then two, the order for acquittal is not passed to the CRO. Actually, I don't know if the PL, I don't know how we can make the system more efficient, but a lot of times the CRO is not aware of the acquittal. So
no, I will be discussing it with the Chief Justice and the parish court judges, that once a fingerprint order is given, I will be urging the court to send the result.
Yes.
If it is an acquittal,
Beautiful.
it is there on record. If it is a conviction, yes, the conviction is recorded. But what usually happens is that the fingerprints are supposed to be destroyed if there's an acquittal.
Yes, sir.
But no one follows up.
No. They follow up when the individual comes now for a clean police record.
Exactly. 20 years' time.
20 years' time. So we say, no, clean where?
And
go
then the
back to the
records can't be
court
found.
and get proof of your... And when they go to the court say, well, Hurricane Melissa, or fire, and, you know, the court is constrained. The court does their best, but there are limitations.
It is a source of major frustration.
I can imagine,
for
sir.
persons who are seeking. They have a clean record, you know, but they were charged. So fingerprints were taken and unfortunately not destroyed after the acquittal. So it is something that I will be discussing, with the court system. How do we deal with it? If once a fingerprint order is given, send the result to CRO or have the records destroyed before it gets to CRO. Yes, Superintendent.
I think the integrated electronic case management system will deal with it.
Will deal with it.
I
Thanks
think it
again,
will deal with it.
And Superintendent Henry, JCF, I'm going to be in touch with JCF, you maybe Alison. Sorry, not as sorry. Yeah, your PS, your PS, Sunroof. Because when the team comes here, I would like them to meet with these different agencies. All of these different agencies, the CRO, everybody, and especially those of you who are here today. That a meeting can be arranged with you people to see how they deal with it in Rwanda, all right? And see to what extent there are variation as the case may be. And they will be here for about 3 weeks, initial, but they will be coming back after that. But it would be nice for them to hear from you so that if there is a variation to the program, it can be dealt with. Okay? Are you finished now, Sam?
To close, sir, I'll just say 2 more sentences. I know we've taken up a lot of time.
No, man, you're good.
One of the things that's very important to us is that the committee consider making attendant regulations. Why we say that?
I didn't hear that. What's it?
Now,
regulations.
Regulations.
Okay.
There are a lot of aspects, well, from a practitioner's perspective, there are a lot of aspects that are left to interpretation, which is fine with us, but you see, to cover ourselves, especially as it relates to our practice and procedure, it would be beneficial that it be codified in regulations. Even the manner in which we give, or the circumstances in which we determine whether we give an informal warning or a formal or a caution, we are thinking to ourselves in order, and I'm speaking as counsel, to protect ourselves from impending litigation. We have to say, okay, this is a manner in which the legislation says we should act, and this is what we did. And it will prevent us from, or at least try to prevent us from, suits for false imprisonment and malicious prosecution if we, and prevent, right, the subjective application of the law. If we can say, okay, see A, B, C here, and we did A, B, and C.
No problem. And right. I think that was mentioned sometime. So the drafts person is here, Mrs. Samantha, even she's sitting quietly in the back, and the legal team from the Ministry of Justice, they're
beautiful.
Sitting there. So,
sir,
no,
I'm aware that the JCF, through its Planning, Research and Development branch, is working on a policy that codifies our practices. So perhaps with the drafting team, we could share some aspects of that.
Please keep in touch.
Which would help.
All right. Unfortunately, time is running out, but Sisoka wanted, is there a possibility you could come tomorrow morning? We'll meet again at 10 tomorrow morning. Those who were to make presentation this evening, is that possible from the other members?
Isn't it finished?
Yeah, we need to close off now. Normally we wouldn't go beyond, say, 4:15, but sure. No additional presentation. Oh, I thought there were additional presentation. But if you have any additional matters such as the regulations and so on, please send it formally to the committee. By the way, all the presentations we will be attaching as an appendix or appendices to the report to Parliament, okay? So if there are any additional corrections that you would like to make, please do that because it will be distributed to parliamentarians and also put on the website. So do that for me, please, as soon as possible. But I would like to thank you, Ms. Trowers, and your full team for being here. I must tell you, I learned a few things today. I thought I knew everything, but I'm learning quite a bit from these committees. And I must admit, colleagues, that we do learn something sometimes. And I'm sure we are coming towards the end. Tomorrow, colleagues, we meet at 10 because we want to go through two other presenters, but we want to do the clause-by-clause assessment to determine overview, and then later on to do whatever changes we can discuss after the clause by clause. And please remind Senator Shireen Golden that she could be here at 10 tomorrow, because she's the one who had and a good idea to look at it, and then we do the matrix, and then we do whatever suggested recommendation to the act itself. Okay? Because we really would like a report to be presented in Parliament in May. And then the committee hopefully could be adjourned sine die sometime in May. All right? I want to thank members, but I'm begging you, I've asked the clerk to let us have at least a snack around lunchtime. If we start at 10 and we may go on until about 1 or so. Okay? Okay. So we consider the meeting adjourned, and thanks everyone for being here. Have a good evening. I don't want to take this. Can I leave these with you? Or somewhere because I'm coming back at 10 tomorrow?
Yes.
I'm going to leave it here.
Doesn't Paul, he takes credit.